Very good morning to everyone. My name is Arno Beers. I'm the Managing Director of AVCO, and I'll accompany our speakers today into a very passionate debate around SFRD, I hope. For the few ones who don't know AVCO, the Austrian Private Equity and Venture Capital Association, just to precise that we represent the interest of VC and PE investors. And it is respect in our mission to collect and share the relevant knowledge for the market. We are very pleased to dive deeper today in one very interesting topic and quite an urgent topic. As one of our event format, we have other events like a yearly conference, an investor breakfast. And all through these events, we connect and share, connect our members and share the knowledge. All information about our mission, events, and all around the association is to be taken from our website. I just can recommend to subscribe to our newsletter. To be top informed about what we do, so now let's switch immediately to our deep dive. A few elements about that. We'll have a 20 to 25 minutes presentation, during which I would ask you to just let the presenters go through their topics. Keep your questions and remarks and post them into the chat, after which we will compile and note all your remarks and questions and ask the questions during the Q&A session after the presentations. Another important point, this presentation is recorded. We will post it on our platform after later today, together with the presentations the presenters have given. So let's immediately start with the presentation. We will first have Christian Richter-Schöller, who is attorney at Dorda, together with Andreas Saratnik, who is partner at Dorda Attorneys. Then we will welcome Johan Weicht, who is associate partner at ERM. And we will finish the presentation with Benjamin Howard Cooper, who is head of sustainable finance at Brink Intelligence. That's all for my part. We want immediately to start with Andreas and Christian, who are a co-lead of the sustainable group at Dorda. So to start with very first expert, Christian and Andreas, the floor is yours.
Yeah, many thanks, Arno, for the kind introduction, and good morning to you all for this AVCO Deep Dive. Yeah, Christian and myself are not only co-heading the capital markets group, but basically we are coming from our banking and capital markets group, which includes our fund practice, which I'm heading. And the reason why basically capital markets and banking lawyers in our firm are dealing with sustainability is, of course, because on EU level, the main regulation, or a lot of the regulation, focuses on the financial sector, because the idea behind this is that the money flow is directed towards sustainability, and thus the regulation, of course, aims at informing the markets on what are sustainable investments and giving people the possibility to make the right choice from this perspective. When we jump directly into the main regulations here and the legal framework, for today, the main regulation is the EU Sustainable Finance Disclosure Regulation. And of course, the taxonomy regulation is also relevant, although the taxonomy regulation is more a general framework and not focused on the financial market as the Sustainable Finance Disclosure Regulation is, and also not that specific. However, we maybe at the beginning should address a major misconception some people still have on in particular the SFDR, the Sustainable Financial Disclosure Regulation, which is that this regulation or also the taxonomy regulation oblige financial services providers or issuers of financial products to design sustainable products. This is not the case, but these provisions are just about transparency and disclosure. So nobody is forced, at least currently forced, to issue sustainable products, but he has to inform the public and potential investors if the products are sustainable according to the standards of the SFDR, and then the market can decide. So who is covered actually, and which products are covered by these obligations? First of all, we have the terms financial market participant and financial advisors who have to disclose sustainability-related information regarding financial products. Financial market participants are, in a nutshell, the creators of financial products. So this would include, for instance, fund managers for UCITS and alternative investment funds, insurance undertakings that manage specific insurance products like the so-called EBIP, so which are insurance products that, for instance, are based on or linked to funds or other financial products. So because in essence, these are insurance products where financial products are an important part of. Then it applies, of course, to credit institutions that manage portfolios for their clients or issue financial products. On the other hand, the financial advisors are, as the name says, people that actually sell financial products and advise on financial products, and also for them certain standards apply. These are, for instance, investment firms that advise their clients on financial products, insurance brokers that sell insurance-based investment products, and of course also credit institutions. So, for instance, a credit institution could at the same time be a financial market participant and a financial advisor. As far as the financial products are concerned, these are instruments that include other financial products, usually like in particular UCITS funds, but also all types of alternative investment funds. And for of course, in the context of AVCO, we should mention that all types of alternative investment fund means that not only licensed fund managers are covered by the regulations, or licensed products are covered by these regulations, but also products issued by alternative investment fund managers that are just registered. It also applies to AVCO funds as well. So the scope is rather broad here. Another important element is, and this distinguishes the SFDR from the taxonomy regulation, is that the SFDR has a broader understanding of sustainability, because the taxonomy regulation just covers environmental aspects, whereas the SFDR covers the full spectrum of ESG, so environmental, social, and governance criteria that have to be taken into account to decide whether a financial product is sustainable. To meet the reporting obligations under the SFDR, it is thus relevant to first understand whether the investment is made regardless of any ESG criteria. As I've said, there is no obligation to do so, but if you don't consider ESG criteria when you issue such a product or advise on such a product, you have to make the investors aware of this fact. Then it's relevant whether it just promotes environmental or social criteria, or even has the objective to have a sustainable effect. And then also it's important to decide or disclose whether the product is compliant with the taxonomy regulation. Also here, you have to bear in mind that even on the environmental sustainability aspects, there is a broader scope of the SFDR. So the environmental objectives of the SFDR go beyond those of the taxonomy regulation. Maybe briefly, what is a sustainable activity from an environmental perspective? For the taxonomy regulation, it basically must comply with one of 6 elements like climate change, etc. So one of these 6 elements must be met. And on the other hand, there must be no significant harm be done to any of the criteria. So this is, for instance, the discussion on nuclear power plants, where on the other hand, of course, it helps on climate change. But on the other hand, we all know about the disadvantages. But the same issues can, for instance, arise with a water power plant somewhere in the Alps, where it helps, of course, also for the climate change. But of course, it may have an effect on nature, which is also one of the 6 elements. So in the specific case, let's say the decision whether the product or the investment is sustainable is not always easy to make. And as you all know, the background of this definition is, of course, not purely to serve the economy, but there are a lot of economic, political, even sometimes almost religious elements in there. And some countries push nuclear power plants like France and others like Austria don't, because of historical and other reasons. So with this, I'll hand over to Christian to dive a little bit more into the various elements you have to disclose.
Thank you. Bringing it a little bit down from this philosophical and more religious perspective to the mechanics of the disclosure, on the details of how you're going to address that new obligations. So basically, the obligations can be divided into obligations that have to be met on entity level, meaning, for example, in context of fund managers, on the level of the manager of the alternative investment fund, for example, and on the other hand, on product level, in case of alternative investment funds, for example, on the level of the fund itself. And on both levels, according to the SFDR, certain information has to be disclosed in order to meet the regulation, and in order to meet the delegated regulation that has been adopted based on the SFDR itself. Why is the delegated regulation so important? Because it's actually delegated regulation that tells you how you have to disclose, and that's highly formalized, highly structuralized, highly formalized in a template format. You have to meet certain criteria of this template that you can't deviate from. You have to check certain boxes in order to meet the regulation. Basically, this is done by filling out the annexes to the delegated regulation that has been adopted based on the SFDR. So for products that are promoting environmental or social criteria, sometimes also called light green products, this is Annex 2 and Annex 4, and for products that have sustainable investments as objective, these are Annexes 3 and Annexes 5 that have to be met either in the context of pre-contractual disclosure obligations, so before the potential client is actually investing, you have to hand over those informations, or in the context of regular informations regarding alternative investment funds, for example, in the annual reports. And besides the pre-contractual disclosures and the regular disclosures, for example, in annual reports. There's also a third element, the website disclosures. Those do not come in template format, but are almost equally formalized and have even more questions that you have to answer. And what's important to know is that those website disclosures also have to be kept up to date pretty much at all times. The extent of the required disclosures depends very much on the decisions made on entity level and on product level. What does this mean? This means that along the way, when you're structuring your product, or when you're setting up the sustainability policies of for example, the fund manager, you can make certain turns, either left or right, and based on which turns you take, in the end, you end up in a place that tells you what you have to disclose. So one very important turn is that you have to decide whether on entity level you consider principal adverse impact of investment decisions on sustainability factors. This is optional for, in a nutshell, for fund managers that have less than 500 FTE on an annual average. What does it mean to consider principal adverse impacts on sustainability factors? This means that you are considering inside-out risks. So you have to check whether your investment decisions impact, for example, environmental, social, or good governance factors. So you have to check, okay, my investment as fund managers, I invest again in certain funds, or invest directly in certain companies. What is my impact with my money flow that I am actually steering into those companies? Am I negatively impacting certain environmental factors? So this is one question that you have to answer. If you do not consider principal adverse impact, then you have less to disclose. Another important question is whether the product that you're selling promotes environmental or social characteristics, light green, or whether it has sustainable investments as its objective. That's considered dark green, light green less, dark green more disclosure obligations. Then another question is whether, if you're only promoting environmental or social factors, so light green product, whether you are still committing to have a minimum rate of sustainable investments, or whether you do not have such a commitment. And the last question, last of the four important questions, would be whether you're committing to a certain minimum amount of taxonomy aligned investments, meaning investments that are considered environmentally sustainable within the meaning of the taxonomy regulation, which, as we heard, is much narrower than the meaning of the SFDR. So after answering all of those four questions, you basically end up in a place where you can decide how much you have to disclose in this structuralized, formalized format. Particularly important is whether you are if you're considering principal adverse impacts. So if you're on entity level, you're saying, okay, I am considering principal adverse impacts on, for example, environmental or social factors. I'm checking my inside-out risks. I'm checking whether my investment decisions negatively impact, for example, the environment. Or if you're committing to a minimum of sustainable investments, in both cases, you have to consider principal adverse impact indicators, which are mentioned in Annex 1 of the delegated regulation, which I just mentioned. Why is this important? Because first of all, it's a very long list of indicators, which can be very hard to track. But we will probably hear more about that in the next presentations. But it's also from a factual perspective, it can be faced with a couple of difficulties, because there still is, and this is pretty much acknowledged also by the authorities, there's still a lack of robust and publicly available data that you can rely on when you're tracking those indicators. Nevertheless, you still have to track those indicators. For example, a couple of indicators mention greenhouse gas emissions, scope 1, scope 2, scope 3, so it's very technical, all the calculation around it. But in any case, you have to track greenhouse gas emissions of your investment, of your investment decisions if you fall into that category. So what you have to do, you have to check, for example, if you're directly investing in companies, you have to check, okay, what are their greenhouse gas emissions? And if, for example, if you're directly investing in companies, you more often than not just will not have publicly available data on that factor. And the question is, okay, so what do I do now? It can be tricky. It can be tricky to figure out how to deal with that. But I think we can go into detail on that in the Q&A. And that's the end of our presentation, and I will hand over to my.
I will do this in transition, Christian. Thank you very much. Thank you, Andreas. It was important to recall the legal and regulatory context. It's very important. I truly believe you could talk hours about that, but it was also important in this group to go more into the practical side of this topic. And for this, I would invite Johan to take up the floor and continue the presentation. Johan, it's for you.
Thank you. I trust you can see my screen, so I'm just going to jump right into this topic. Yes. The element I've chosen for my part of today's input bit is how the SFDR and taxonomy correlate from a disclosure point of view. Our colleagues from DORA alluded to it already. It may only be something you have to do depending on how you label your fund under the SFDR, in particular if you're going for an Article 8 dark or an Article 9 fund. But that's one of the general trends we're seeing in the market, that this is certainly a direction of travel that the big potential LPs, so the big pension funds, big asset managers, etc., are going for and requesting. So I think it has quite a bit of relevance. Before I go into the operational details of the disclosures, let me just briefly reflect on a couple of the key challenges we see in the market. From a legal point of view, there's definitely a bit of hesitancy to, fully commit something you might not be able to fully understand at a certain point in time. Looking at the historical development of both the SFDR and the taxonomy, there have always been rather big delays between the initial regulations being published and then very relevant delegated acts, delegated regulations being announced sometimes 2-3 years later, while the disclosure obligations were coming closer and closer. So that's definitely a bit of a challenge, particularly related to the EU Taxonomy. I trust you will all have heard by now that this is supposed to be a living document, meaning that more economic activities will come into scope over time. Technical screening criteria for sustainability, compliance, and performance will also change over time. So that's definitely something to keep in mind and to be in a position to track what that means for you as an entity as well as a financial product level. Then, interestingly enough, and kind of in an opposite direction of that Article 9, Article 8 dark trend I've just mentioned, we would say that there's actually a lack of deeply sustainable assets in the market, at least to date. The EU Commission itself estimated that taxonomy alignment in terms of turnover, OPEX and CAPEX of the real economy is potentially going to be at an average of less than 5% for the first couple of years. So that sends quite a strong message. And then if you look at some of the procedure requirements for Article 9 sustainable investment funds, there's definitely an expectation for these to be sustainable from day one. But obviously, considering the macroeconomic environment, there still needs to be a lot of capital put into the actual energy transition and the business transformation of companies. So that's also a conflict. Third point is around the multi-stakeholder alliance for making SFDR and taxonomy work. just listing a few sort of functions and stakeholders that are typically required to make that happen. On the SFDR side of things, it potentially can span the entire asset management company and also the portfolio companies in terms of gathering the data. Obviously, then it's a balance between GP and LP interests. On the taxonomy side of things, it's definitely necessary to make financial and non-financial data interact and talk to each other, which for most companies historically has not been the case. And then finally, in terms of the business transformation side of things, we would also argue that the integration of the business case for sustainability transformation into the investment case and investment hypothesis of most of the financial products out there in the market right now is pretty much still in its infancy, and also especially in a private equity, also in a venture capital context. Obviously, if you consider this from a financial investment case perspective, it's always a question based on your envisioned holding period, whether and how much you're able to actually monetize the transformation you're seeking to make within the portfolio companies. So with that being said, let me jump into a little bit of a case study here. Again, this is for SFDR periodic reporting as it relates to the EU Taxonomy disclosures for portfolio level alignment of turnover, OPEX and CAPEX of the portfolio companies. You will see that we broke this down across 4.5 steps, and I'll quickly walk you through the main points. You will also receive the slide decks and then you can dig into it yourself. So on the preparation side of things, before you even start looking for data, we definitely highly recommend pre-screening your portfolios and trying to identify the one potentially biggest eligible economic activity for each of the portfolio companies. In most cases, that's going to be from a turnover perspective. And second big step is about education in terms of all the stakeholders potentially required in the project to gather the data. We recommend starting with what the output looks like, and then depending on whether you're talking to the ESG or the finance people, give them a first glimpse already of what data you are most likely going to be asking for in a couple of weeks further down the line. Now, next step up is about taxonomy eligibility, so the economic activities that fall in scope of the taxonomy regulation and its delegated acts. Probably biggest step to keep in mind here is non-sales related CAPEX and non-sales related OPEX. In our experience, this is something typically overlooked by most companies in the market, as they tend to focus on, well, we generate turnover from X, so we will definitely have OPEX and CAPEX linked to that, which is totally right. But there are a couple of economic activities that every company tends to have, talking about the real estate, the offices you're either owning or leasing, for instance, talking about perhaps the company cars, etc. And then second big point here is try to prioritize by the financial volume of these activities, because especially in the first year, you probably won't be in a position to assess all eligible activities against alignment. And please do yourself a favor, document every assumption, every estimate, every decision you make, and try to apply it in the same way across all portfolio companies, because else you're setting yourself up for a big mess further down the line. For the alignment assessment itself, for us, the biggest point is trying to break down the complexity of the technical screening criteria of the EU taxonomy into yes or no questions. Because regardless of whether you have a sustainability or ESG background or not, it's always easier to answer a yes or no question rather than a very open-ended technical question, and store all the documents in the same place. Last point I'm going to make on this slide is when it comes to the actual calculation, start by replicating the structure of the financial product. So are we doing equity, debt, bonds? Are we investing into real estate, infrastructure assets, etc. in the tool? What are also the sort of holding percentages? For instance, if we're talking equity, am I holding 30% or 100% of a given asset, for instance? Then gather and input all the financial data. That's obviously pretty self-explanatory. and integrate the alignment assessment outputs. And this, depending on how you sort of build out that tool, then gives you the aggregate portfolio level view. In light of the length of my speaking slot, I'm going to skip over the evaluation and go right into sort of the subtitle of today's session, how technology can help, which then also leads into the next slot from Brink. So we at ERM have a couple of tools available that can help in the SFDR and taxonomy section. ESG Fusion particularly helps on the SFDR risk disclosure element, so potential financial and valuation risks coming from a sustainability perspective. And then we have several tools, CRISP, Emissions AI, Net Zero Compass, that help in that climate mitigation, climate adaptation field by assessing physical climate risks, calculation, emissions intensities, and optimizing emissions performance. And last point I'm going to make is that we also have a software offering called Librio, which is basically a subscription model to get updates on relevant environmental health and safety and ESG regulations, to also get notified whenever something changes within the SFDR or taxonomy. And that's it from me for today.
Thank you very much, Johan, for this overview and the details. And we will now continue to go even more precise with Benjamin Orward-Cooper. Well, Ben, I'll leave you the floor.
Great. Thank you very much, Arnaud, and thank you to everyone for joining this morning. And a big thank you to my esteemed panelists for, I think, really setting the highlights for why we're all here today. And I think I get the easy job, which is really to explain why everything is not all doom and gloom, and how there are solutions to help you navigate what are reasonably complex topics. Great. So I will start by just reinforcing some key points that were made by some of the other panelists around why taxonomy reporting matters. I think very clearly you have regulatory and legal obligations that you certainly don't want to come into conflict with, but there are also some carrots in addition to the sticks motivations here. I think clearly we've seen that there are opportunities to attract more capital from LPs and institutional investors who care deeply around sustainability. And we'll look at the taxonomy and SFDR as being barometers of a particular product or entity's sustainable credentials. I think from a money-making perspective, there is certainly an idea that you can increase exit multiples as you continue to demonstrate the narrative around the portfolio company's sustainability profiles. And of course, there's a reputational pull here as well, giving you an advantage in the market. And I think particularly in these economic times, any leg up really can help. But taking a step back and thinking about this holistically, I think we know that it has not been easy to understand the sustainable profile of target companies or portfolio companies. I think particularly when you're investing in private markets around SMEs, you'll often find that there just isn't the level of understanding at the portfolio companies to build out some of the policies and procedures that are core to some of these sustainable frameworks. And I think it's important to recognize that a lot of the sustainable regulation solutions for private markets are applying a public equities perspective. And so a lot of the solutions that are being developed don't necessarily fit very well, which leads to a lot of frustrations in private markets. And what I want to explain for the next 8 minutes or so are some tips and tricks how to get around some of those mismatches and misalignments between the regulation and the reality on the ground. So I think Johan sort of started on this, but I'll just take it from a little bit of a different angle. What does taxonomy reporting look like? I think the first step is really to understand your firm as a whole. So really setting up your finances, and taking a look at the eligibility list. And what we at Brink do is we take a holistic view at the regulation and look at it more as a supportive framework than a binary yes or no. So I think there are different approaches, and I think that speaks to sort of the Wild West nature of where we are in sustainability world right now. But what we try to do is really look at the eligible activity description and understand what is the commission and what is this regulation really trying to understand as being the core activity within this business. So not taking a NACE driven approach, but really thinking what is the economic output and how does that align to the descriptions within the taxonomy regulation. This can have meaningful impacts because when you look at the taxonomy regulation, the requirements, the technical screening criteria, all flow from this concept of an economic activity. deciding which economic activity you pursue for booking your taxonomy KPIs has very different impacts on the types of data that you need to collect, and also on the performance, the sustainability performance that you need to achieve in order to be aligned. So it's really important as a first step, understand what is the eligible activity that this firm could apply for, and that might involve a little bit more of a philosophical activity, really thinking about what are these entities doing and how might we take different pathways. Of course, the next step is really to look at alignment, and this is where a lot of the data-heavy document collection comes into place, which has frustrated many financial market participants and portfolio companies. It's a different way of working, and it means aligning sustainability credentials behind financial KPIs, which is really a first requirement that we've seen in the market, and I think has reasonably led to a number of different questions. I think Johan rightly pointed out, document. It is critical to make sure that you are putting key parts of evidence behind some of these alignment criteria, so that when regulators and auditors do come in, you can demonstrate that you aren't just greenwashing your EU taxonomy report, but that you are really aligning some evidence behind some of these key clauses. It's not listed on the slide, but of course, this is just the environmental portion of the taxonomy. There is sort of step 2, which is the minimum safeguards, which speaks to a company level performance against certain core labor and human rights issues. Similarly, that involves a heavy level of data collection back and forth between portfolio companies and investors to ensure that the right policies and procedures are in place to not fall afoul of the regulations that are listed out there. This is also an iterative process. I think, as previous panelists noted, we're only expecting a little bit less than 5% taxonomy alignment in the few years, but this is a living, breathing document. We will continue to see additional economic activities included in the scope of the taxonomy. We may very well see changes in the application of the technical screening criteria. And I think as a tool, it's really helpful to look at taxonomy performance, look at the evolution of taxonomy performance, and use that as a barometer of how this firm is evolving, not only in terms of its core revenues, but also in terms of its sustainability performance, which can be measured through its taxonomy alignment. I think, again, we know that there are a ton of challenges, and really what I want to focus on here is really about the breadth of data that needs to be collected, and different types of data than portfolio companies and investors are used to collecting. And I think the other difficult part around the data collection as it relates to the taxonomy and SFDR is that we're not talking about neatly standardized financial data. We're not talking about sort of the base level of documents that you're used to collecting. We're talking about unstructured data that lives in many different parts of a firm. So that really requires a strong level of collaboration between a number of different stakeholders in order to even understand where these KPIs might live, to understand where you might be able to pull the data that you need in order to do effective taxonomy reporting. So that means even at the portfolio company level, there's a substantial amount of back and forth that needs to take place across the key stakeholders. And that's before investors even get involved. And so there need to be certain tools in place in order to facilitate that, particularly for large investors that might have upwards of 20, 30 portfolio companies that might be required to do a taxonomy assessment. You can see that these challenges continue to balloon. And so having some sort of system in place in order to track and manage that document collection back and forth, we've found has been critical for many of our clients who have been able to leverage technology in order to really make sure that they not only feel comfortable that they have an auditable trail of their taxonomy reporting, but that they're able to communicate across all of their stakeholders and do this effectively. Because every dollar and every minute that's spent working on taxonomy reporting is a dollar or a minute that's not spent really delivering impact for your LPs. So in addition to a user-friendly software system that we've developed that helps lead portfolio companies and investors through the step-by-step process for taxonomy alignment, what really drives us here at Brink is the adoption of natural language processing and broader machine learning technologies in order to support a lot of this reporting work. So I think, as I mentioned a few slides back, a lot of this ESG data, a lot of this ESG evidence lives in unstructured documents, lives in your annual ESG reports, but it also lives in certain policies and procedures. It can live in press releases that are on a company website. There is no standard way to collect, aggregate, and report out on this ESG data. So while having a tool in place in order to manage the document flow back and forth is critical, really being able to leverage technology to do some of the evidence gathering and evidence alignment becomes even more so. And that's where we really see the power of technology come into place. So we've established some natural language processing models that are able to look at this unstructured data and to link some of the evidence to the core clauses. So I think important, as we've mentioned a couple of times in this webinar, when you're thinking about the taxonomy, you're really thinking about a questionnaire of clauses that you need to satisfy in order to demonstrate alignment. Now, being able to use technology in order to automatically look at a virtual data room or look at the full universe of documents, understand what core evidence is there, how it links back to the taxonomy, and do some of that pre-sorting work really is an incredible time saver, and also creates a sense of unbiased nature when it comes to looking at the evidence. You know, there's a standard methodology and model that goes into looking at some of that core evidence, and it helps align it so that either an auditor or a fund can come in afterwards and decide whether or not that evidence stands muster. And I think another important point that was raised by the lawyers in the room is you know, there is some gray area here. You know, I think we're still trying to figure out exactly where regulators and where national bodies will fall when it comes to applying some of the levels of evidence that are required. So really important to create a auditable trail so that you can justify some of the decisions that were made. And that's it for me. Let's turn it over to some questions.
Thank you very much, Ben. And thank you again to our speakers. I think we've been a little bit longer than planned, but it was necessary to get from the very regulatory point into practical case. So now we'll open the floor for questions, and I'd like to give you a couple of minutes to prepare your questions and ask the first question. Well, pretty evident. So now we know. And I will put it very simply. Now we know what has to be done. What happens if we don't do it? Is there any audit? Is there any sanction? Is there any timeline where all this will arrive? So, well, probably we'll start with the lawyers, but I think the question applies to every single one of you. So maybe Christian, you want to start?
Sure. Thanks for the question. So to address your first point, there is no audit. This also touches on there's no external audit, to be very precise. This also touches on what Andreas mentioned at the very beginning of this presentation, that it is not the SFDR doesn't really oblige anybody to only create quote unquote green products. And on the other side, the SFDR doesn't produce some kind of label that you can put on your products and then say, okay, because I am disclosing under Article 9 SFDR, so as a dark green product, that's why I am a certified dark green product. That's not how the SFDR works. The SFDR only says, if you reasonably assume, if you pursue from the assumption that you are a dark green product, that your product has sustainable investments as an objective, for example, then you have the extended disclosure obligations pursuant to Article 9 SFDR, but it's not some kind of label. And this is also why there's not some kind of external audit where the auditor says, okay, yes, you're actually pursuing sustainable investments as an objective. Here's your proof. Here's your proof of it. So no external audit. It's only self-assessment, more or less. And you also mentioned what happens if you don't meet the disclosure obligations. So from a legal point of view, there's of course the administrative law side, because the SFDR is more or less integrated in an already existing and very dense, as many of you will know, a very dense regulatory framework of disclosure obligations. And that's why if you if you violate the SFDR disclosure obligations, the administrative law consequences are pretty much the same as when you, for example, violate any other pre-contractual disclosure obligations. So, for example, in the context of alternative investment funds, that would be that could be administrative fines by, in Austria, the competent authority, the Financial Market Authority, the FMA, up to euro 60,000. That's the maximum amount that the FMA could impose for violation of disclosure obligations. That's in essence the same amount that would apply for almost any other disclosure obligations. So also here the SFDR obligations are integrated in the already existing framework. But I think more, or at least equally relevant, would be civil law consequences that maybe Andreas can elaborate on.
Yeah, I mean, in practice, I think you have several elements on the civil and competition law perspective. One, of course, is the famous greenwashing. So that you, even if you kind of meet or purportedly meet your disclosure obligations, but the information you provide is incorrect, then of course competitors or consumer protection organizations could sue for unfair competition. And which could result in the first place in that you have to change the disclosures in line with the law and cannot use the wrong disclosures anymore. This would also raise costs and could also result in damage claims. I mean, there are in Austria, there are specifically regarding funds, no examples yet, but if you, for instance, look into Germany, there's already case law where, for instance, a fund that declared itself as an impact fund said, okay, for every 10,000 euro of investments, you save a certain number of tons of carbon emissions. And this information in court proved to be wrong because the number given was only correct under certain circumstances that did not always apply. And therefore the fund here basically lost the proceedings, and this had a lot of echo. So the problem here also is, even if the cost of the proceeding might not be too high, there are a lot of reputational problems resulting from such proceedings, because such decisions then are also published, and therefore the public will know it, and media may take it up, etc. The other element is individual claims by investors. Also here, it's basically a new field for lawyers, because it's, let's say, not so easy to say if you buy a product under the assumption that it meets certain sustainability criteria, if this automatically leads to a damage, or whether if you get the product that you did not want, actually already entitles you, for instance, to, even if you don't have a monetary damage or loss, entitles you to give the product back to the issuer, simply put. And also here, I think this would have then several elements. The one, of course, is that investors could argue that in case they suffer a loss, that actually they wanted to invest into a sustainable product, and if they had known that the information given is not correct, they wouldn't have bought it, and therefore the issuer or the advisor has to reimburse the loss. This is one scenario, but there could also be scenarios where even if it's unclear yet, or if there will be a loss, the investor wants to get out of the investment. If you, for instance, look at a fund of fund who invests in other funds, and the fund of fund has as investment criterion to only make sustainable investment, it turns out another fund, the target fund he invests in, is not really sustainable. He, of course, would also want to get out of the investment immediately, because otherwise he would meet his own criteria. So all these sorts of issues will be sorted out by case law in the next years, but we can only warn to kind of use the sustainability disclosure as only marketing tool, but really check whether all the information would stand up to a test in court and by a court expert, for instance, who then would decide whether the information is really correct, for instance, on carbon emissions or other things.
Let me perhaps add two very brief points. I think the last remark from Andreas that LPs might be pulling their money from an investment fund. This is already happening, and in response to that, especially in the public markets side of things, there have been certainly a much larger number of fund classification downgrades in the last 2 quarters than there have been upgrades. So this is definitely a real risk to be aware of. Second point is that ESMA, the European Securities and Markets Authority, have put combating greenwashing as their #1 ESG priority for 2022 to 2024. So there's a lot more to come from ESMA to the competent authorities in each EU member state, and through that potentially to each entity that is affected by the SFDR.
I would just add one last point here. Keep an eye on the national regulators governing your own operations, because this has been a really dynamic area and what is already a very fast-moving regulatory landscape. I think here in France, just a couple of weeks ago, the AFM clarified that the level of sustainable objectives only needs to be accomplished at a period through which the fund can self-identify, which contradicts a little bit with some other European jurisdictions saying that you have to hold your sustainable objective percentage throughout the lifespan of the fund. So depending on where your fund is sitting can have really real ramifications for your investment strategy. So definitely keep an eye on that. And I think we'll continue to see some loosening of some of those regulations. I think one of the common feedbacks around all of this has been it's just too complicated and too strict to apply from day one. And what I've seen is regulators really trying to calm markets down and say, okay, we understand. Here's some grace periods. Here's some additional slack that we can give you.
Maybe to briefly kick in here, because you said, for instance, the question at which point in time you meet the sustainability criteria, just when investing or also over time. I think here, apart from the regulation, it's of course also very important what the placement memos, etc., say in this context, because we looked at a lot of documents from this perspective, and there's really a pretty large scope of various internal definitions, so to say, of funds that declare themselves as being green or dark green, what they actually, if you look at the fund documentation, then do, and some say, okay, at the time of the investment, but others have a more general approach, and I think this is also important to really draft your documentation very carefully in this respect.
Okay, very clear. Thank you very much. At this stage, I would like to thank Tobias, who has helped us to organize this deep dive, and maybe ask him whether he would have a question to raise in this round.
Yeah, I mean, I think something that interests me coming from this perspective of, a law firm, a consultancy, and then a tech platform would be to gain a bit of a different view from everyone on, should you request this data from portfolio companies? Should you gather it for them? And how can you actually engage with those portfolio companies?
I can kick it off. Thanks, Toby, for the question. I think it really depends on your own set of preferences and maybe the way that you already work with portfolio companies. I think we know that there are fund managers who are more hands-on and some that are more hands-off, which I think has also reflected in the broad range of strategies around collecting some of this data. I've seen strategies as broad as a fund manager sending a blank Excel to a portfolio company and saying, send me your taxonomy eligibility and alignment percentages, taking some recent guidance from the EU Commission that self-reported company data is sufficient for the taxonomy. I think that's probably a very bold approach and probably one that wouldn't necessarily want to be replicated by some of the more conservative members in this room today. But I've also seen a lot of funds really use the taxonomy as an opportunity to deepen their engagement with the firm. So really using this as an opportunity to spark communication, to set up really good and robust pipelines of communication, and not just view it as another regulatory burden, but as an opportunity to establish new ways of working together, establish trust and transparency around the firm. That's my 2 cents.
From my point of view, I think we need to differentiate a little bit, because there are certainly points within the SFDR and taxonomy where the regulators are actually requesting you to use self-reported company data. That is, for instance, in all cases where an investee has a reporting obligation under the taxonomy by themselves. If you're invested through debt or equity, and then you have to rely on the self-reported data, and only in all other cases you're allowed to sort of estimate for them or calculate for them or use sort of third-party data. That's one point to keep in mind. I think the more general observation is that regardless of the approach, it probably is very much advisable to give certain guidance, because what you want to avoid is that, you get a bunch of data points without any context as to what they actually sort of entail. Best example, I mean, the other panelists have mentioned greenhouse gas emissions a couple of times already, so let me use one of those examples. Scope 3 emissions alone have 15 subcategories, so you might be getting 15 from one, 3 from another. How can you compare that if you don't know what's what?
Yeah, I think that's an excellent point. And to the fact, I mentioned it before, that there still is very much a lack of robust data, both in terms of quantity and quality on the market, is also widely acknowledged by authorities, at least on EU level. And I know that, for example, the Austrian regulator also acknowledges this fact. This is, for example, also evidence that in some of the questions you have to answer under the disclosure obligations, in the explanatory remarks, it says that you have to disclose how much of your data is based on primary sources, for example, involvement with the fund manager, and how much is based on more or less a best estimate basis, meaning that the authorities already pretty much know that there will not, you won't have the chance to base any and every data point that you need to disclose, even if you are in the more broader range of disclosure obligations. That there's no chance that any and every data point will or can be based on primary sources, can be double checked, etc. So stuff that you would usually do if you're more in the, let's say, realm of financial data, that's maybe not possible in the realm of non-financial data at all times. So I think that the authorities are pretty much aware that this is something that at least at the moment is causing some difficulties, but consistently, if they are asked, so how should we do it, they're saying, okay, with even more and more disclosure obligations on the sustainability related front coming into action, this problem will more or less solve itself. So they're especially relying on the CSRD and the even ever extending scope of the CSRD, that more and more data will be available in a more and more robust format.
Thank you, Christian. And well, we're running a little bit out of time, but we still want to take a couple of questions from the audience, and there is already one by Marco. You can see in the chat, who wants to know, well, how do you assess the obligation of transparency in Article 4 SFDR with regards to due diligence policies? It is known what to report on regarding due diligence, and has this transparency obligation in Article 4 been manageable thus far?
I can start on this one from a technical perspective, and probably makes sense for Christian and Andreas or Ben also to add in. So I would say it depends, first of all, on the overall positioning of the entity or particular fund. That's the Article 7, that's principal adverse impacts on product level, not entity level. It comes down to what you're promising ultimately. I see a lot of investors trying to assess principal adverse impacts already at due diligence stage. as per my understanding, it's not necessarily a legal requirement to do so, but if you think about it, it makes sense to do so, because if you're trying to use that perhaps to make a sort of, go, no-go decision on a potential investment, obviously you need to have that data ready at DD stage. Could also be very much relevant, as a lot of these principal adverse impact data points in one way or another are required to assess whether you're making a sustainable investment or not, and then given on what percentage of sustainable investment on a fund level you might be committing yourself to, obviously you might want to find yourself in a position to, again, make that assessment before you commit any significant money, only to then later have to invest significantly more to then transform the underlying business.
Okay. Anyone wants to add something on that? Otherwise, I could switch to Alexandra's question about who will be responsible to check and testify the ESG reporting status as 8 or 9 fund of fund auditors, and what will be the role of financial market authorities?
I can take that one, or I can at least kick it off.
Yes.
So basically, how the SFDR works is that it doesn't, as mentioned before, it doesn't say if you meet criteria A, B, and C, then you're an Article 8 fund, and if you meet criteria Article D, E, and F, then you're an Article 9 fund. But it says if based on your self-assessment you're an Article 8 or Article 9 fund, you have to disclose certain information. Whether you are disclosing all that information based on your self-assessment, that is primarily checked by in Austria the FMA, or in the other jurisdictions by the national competent authorities. So that's checked by the local regulators, more or less. But of course, as Andreas mentioned, civil courts might also have a say in that. If it comes, for example, to the situation that somebody is alleging misrepresentation, and then that might also be relevant for civil courts. So there's no auditors involved in terms of external auditors or annual auditors. They wouldn't check that, at least not within the framework of the SFDR.
Okay, questions are starting to pop up. I have one interesting one, maybe for Benjamin, maybe. How can all these requirements be handled by smaller investee companies? It seems like there is a lot of capacity needed that often small companies just not have.
I think that's a very good point, and it's certainly true. I do think part of it is a little bit of an inflation of how scary things are looking at the European Commission legalese. I think if you take a step back and you look at specifically what are they asking for, then it starts to become a little bit more straightforward. There are a set of documents and analyses that need to be done on the firm, looking at sort of the impact, that inside-out assessment. And there are a number of policies and procedures that need to be in place depending on the exact activity in order to assess outside-in risks. And this is really the double materiality concept, really thinking about ESG not only as a risk framework, but also as an impact framework. And a lot of what the taxonomy asks for are different pieces that would speak to both of those. I think for small businesses or SMEs in general, to not get frustrated when you find out that this entity isn't going to be taxonomy aligned from day one. This is the start of the process. You know, you have your sort of robust understanding of how one of your portfolio companies might fit into the taxonomy. You've started to understand what their eligible activities are. And now you have a good gap analysis of what needs to be done to the firm in order to bring it into alignment. So is that something simple or straightforward, like doing a physical risk assessment or doing one of these sort of outside-in assessments? Or is it something a little bit more complex? You know, is there a scientific threshold within the technical screening criteria around the emissions of GHG, and right now their performance doesn't match that? You know, that's going to be a little bit more of an investment in really changing the business model in order to bring it into alignment. So yes, there are certainly going to be frustrations with fund managers working with portfolio companies who don't have that level of ESG savvy. But I think this really speaks to why it's important to have certain solutions in place, either technology or through some other means, in order to help communicate with portfolio companies around really what is being asked for, not just throwing them loose to the legalese of the delegated acts and saying, figure it out yourself, but really using this as an opportunity for sensitization and education.
Thank you, Ben. Elaborating a little bit further on one of the questions, do you see any in foreseeable future any threshold underneath which you would not be obliged to disclose?
I can
yeah.
start off with that one again. So thresholds would somehow indicate that there's some kind of quantitative, meaning in terms of numbers, percentage, or etc., threshold that you have to meet or mustn't meet in order to have to disclose or not have to disclose. I think this is not what. So this is not what the SFDR is about. But also, I think it's important that it's not only a quantitative, that you can't only take into account quantitative, but also qualitative criteria. So how it is framed is that if you are an Article 8 fund, if you're promoting environmental or social criteria. So that's less about numbers, but more about the question, am I promoting environmental or social criteria? Of course, looking into the details of how you're going to answer the question, at some point, some kind of numbers or threshold or quantitative context will become relevant. But that's not the primary question. The primary question you have to ask yourself is, am I promoting environmental or social criteria? This can make a difference, for example, in cases you have investment options with your product, because it's not, this is when, for example, you have a product with 50 investment options and only one of those can be considered to promote environmental or social criteria. And then the interesting question comes up, okay, what about my multi-option product? Is it now looked at it in total? Is it now promoting environmental or social criteria or not, given that only one of the options is actually doing so? So I think looking at it from this perspective shows that it's not about numbers, but more about, at a holistic level, does it promote environmental or social characteristics? Or in case of Article 9, is it pursuing sustainable investments as an objective? Where numbers come in, and of course, it's a good question, because it's also a question that is very relevant and also a question that comes up a lot, especially in the past couple of months. I think somebody already mentioned that in Q3 and Q4 2022, there has been a lot of shift from Article 9 to Article 9.8 fund volume, and I think a lot of that is can be attributed to some draft paper that the ESMA published on ESG and sustainability funds, where it said that if you're using ESG, sustainable impact, or some other similar word in the name of your fund, then you have to meet certain quantitative criteria. This is a question that is separate from the SFDR. This paper, it's only a draft stadium. It's at the moment it's open for consultation still, I think. But in any case, it's not final. But still in its draft stage, it caused so much. It caused a pretty big shift. Why? Because the thresholds that the paper sets can be considered pretty high. So it's somewhere around 80%, more or less, depending on what you're using in the name of your fund. So that's where the quantitative thresholds come in. But that's a question that is separated from the question, am I meeting the disclosure obligations under the SFDR? The SFDR itself doesn't impose this kind of threshold. That's also not the objective of the SFDR.
Thank you, Christian. There is a precision we need on Edgar's question. Johan has already given some elements of answer in the chat, but there is a question about admissibility. When you issue an Article 8 or financial product as an FMP, but you're not taking into account PAIs. Maybe Christian or Andreas, you want to give a small precision about that.
I can try that one. I mean, you could, so principal adverse impact indicators are relevant from two sides, pretty much. The one side is if I am considering principal adverse impacts of my investment decisions on sustainability factors, that's the inside-out part, then I have to disclose pursuant to those indicators. Whether I have to do that depends in a major part on whether I have more or less than 500 FTE on an annual average. If I have less, then I have the option to do so, to do disclose or to not disclose. If I do not disclose on entity level, then I also do not have to disclose on product level. So from this perspective, I can build an Article 9 product that doesn't disclose on principal adverse impacts if I do not disclose on principal adverse impacts on an entity level. However, and that's mandatory under Article 9 and that's optional under Article 8. If I commit to a minimum of sustainable investments, then I still have to deal with the indicators mentioned in the table, at least in table 1 of Annex 1, because to assess, and this is I think something that Johan already mentioned before, if I am committing to a minimum rate of sustainable investments to assess whether an investment I'm going to make can be qualified as sustainable within the meaning of Article 2, number 17 of the SFDR, I also have to check whether it doesn't significantly harm any ESG goals that the SFDR is imposing. And how do I do that? I do that by considering the principal adverse impact indicators mentioned in Table 1 of Annex 1. So from this perspective, if I'm committing to a minimum of sustainable investments, I still have to take those indicators into account.
Okay, very clear. I think we could really discuss hours about that. So maybe we should head to the end of today's session. I would like to give each speakers a very brief opportunity to send a closing remark before finishing with the call. Andreas, do you have any well, a couple of words to finish the intervention?
Yeah, I mean, I think the discussion showed that is definitely a topic that's will be stay and will keep us busy for the next years. It was mentioned that also the regulators put more and more focus on this area. I still remember that even a little more than a year ago, I spoke at a conference, and then I was still asked whether this is something that will go away again, this topic, and if it's really necessary to deal with it. And the answer is a clear yes, it will not go away. And it's good that it will not go away, even if you can dispute the details on how this is implemented. But nevertheless, everybody will have to put a focus on, and also we are seeing, of course, that the market is demanding it.
Johan, your closing remark?
To me, SFDR and taxonomy really come down to a bunch of expectation management and balancing interests between all involved parties. And from that point of view, I would always make the case better spend more time up front than being a little bit too quick and then having to redo all the work whilst you're already under certain commitments, be there from a regulatory nature or from a stakeholder expectation point of view.
And Ben?
Good luck. No, no, I think the piece of advice is really to try and think about these regulations as being supportive frameworks, as being opportunities to set up new systems and new ways of doing work that will only help enhance your overall operations. to obviously follow the law. I know there are lawyers on the call, so I'm not going to say otherwise, but obviously do all of your legal obligations, but also think about really what is the intent of some of this regulatory language. Really what are they trying to achieve? And I think very clearly, like Johan was saying, do the work up front, make sure that you have the right tools necessary in order to do this work properly. Don't try and bootstrap it, because there's just going to be a ton of work that comes in the back end to fix anything that needs to be readjusted. And I think in this environment, you want to make sure that you have the best foot out there with your LPs and broader stakeholders, whether that's regulators or anyone else.
Oh, good. 2 words, Christian, maybe. Other than good luck.
Other than good luck. Yeah, so I think what turned out to be very important in our perspective is to convey to clients that it's not an entirely new legal area, and it's also not something that has never been seen before. But I mean, in the end, it's all a risk-based approach that you have to take when you're doing those disclosure obligations, as is the same when you're doing other disclosure obligations. So you have to, of course, you have to do your best to meet those obligations. But of course, in the end, it all comes down to breaking it into actionable steps, and to not get overwhelmed by the technicalities, by principal adverse impact indicators and how am I reporting on indicator number 13, but to do your best to meet those obligations at a time when, as mentioned before, the situation around the data that is available, at least publicly available, is less than optimal.
Oh, very good. Well, then I would like to extend a very warm thank you to our speakers today for the very clear insights, and probably we would need an additional session to continue the discussion. Why not? Maybe and at this stage also a very warm thank you to the audience. You've been well, a great number today to listen to this topic. Don't hesitate to give us some feedback. If you need more information about this topic, we can always organize a new session later on this year. Don't forget, you will receive the presentation, and you will be able to watch again the whole session in our video, in a video cast later on. You will receive the link. In the meantime, I wish you a very good Thursday. And I believe if you need more insights, every single speaker today will be available offline to continue and to help you. So thank you very much again. If we would be in a physical room, you would certainly receive a big round of applause. Thank you very much.